Good morning, and thank you for sharing part of your day with us. I'm Vincent Kamsky, I'm a partner at Edward J. Plummer and Dodge here in New York. And I'll introduce our distinguished panelists shortly. After 9/11, President Bush authorized the use of unmanned aerial vehicles to target and kill Al-Qaeda and Taliban leaders. He did this pursuant to the congressional authorization for the use of military force, and he designated the combat zone as Afghanistan and the airspace above. The U.S. has held strikes in other countries. This unmanned aerial vehicles are commonly referred to as drones, and if you're going to be more precise, either predators or reapers. This subject first received widespread attention in November of 2002 when a CIA strike took out the mastermind, let me say alleged mastermind, of the attack on the USS Cole, that was a strike in Yemen. The UN Special Reporter on Extrajudicial Executions called it a clear case of extrajudicial killing. The U.S. defended it as being consistent with the law of armed conflict. And the law of armed conflict is sometimes known as the International Humanitarian Law, IHL, people may slip into that, or more colloquially as war law, law of war. Now, President Obama has dramatically expanded what's come to be known as the drone program. CIA Director Leon Panetta called it the only game in town in terms of disrupting Al-Qaeda leadership. The U.S. government numbers are that this year more than 400 militants have been killed and fewer than 10 non-militant casualties have occurred. Peter Berger, the Center for New American, has a different set of numbers. He thinks this year about 8% of the casualties are non-militants, and in the previous 5-year period it was 28%. Both supporters and opponents of the program have urged the Obama administration to articulate a legal justification. And the administration did so in March of this year in interesting circumstances. I'm not in the legal academy, I'm a practitioner, but watching it was interesting because many of you in the room will know and publicly revere Harold Coe. Harold Coe is the international law professor who was dean of Yale Law School. He was given the task of laying out the legal justification at the annual meeting of the American Society of International Law, and many of you may have been present for that. In his speech, Mr. Coe said that it is the considered view of this administration that U.S. targeting practices, including lethal operations conducted with the use of unmanned aerial vehicles, comply with all applicable law, including the law of war. He offered several justifications, said enemy leaders are legitimate targets because they're belligerent members of an enemy group at war with the U.S. He said that drones are appropriate instruments as long as they comply with the law of war, which we do by applying the principles of distinction and proportionality. He said that enemy targets are selected through robust procedures which require no extra legal practice, no extra legal process, and the killings are not unlawful extrajudicial killings. And he said that using drones to target high-level belligerents does not violate the domestic law banning assassinations. He also likely, I thought, added another important potential legal justification, and that's, in addition to the law of war, the inherent right of self-defense that exists under customary international law. It's interesting because the legal academy, to use a term of art, went ballistic. Blog or ablaze. I think it was a peer review or someone wrote something like this. This is an example of why no professor should ever go into government. There was an intervention recently when it's been revealed that the target list includes an American-born Yemeni cleric, Anwar al-Awlaki. He's a an American citizen, original birth. He's based in Yemen. He's a leader in Al-Qaeda in the Arabian Peninsula. And he's been linked to the Fort Hood shooter and the would-be Christmas Day bomber. Last August, the ACLU and the Center for Constitutional Rights filed a lawsuit on behalf of Alaki's father, seeking an injunction against strikes against Alaki on due process grounds, and they also took on the law of war and self-defense challenges. One of the things that's interesting in this to me is the emergence of a disconnect between the American public and the government on the one side and the academy on the other. I think there's really widespread acceptance in the government and in the public. Even the New York Times' last editorial on the subject, as I read it, was sort of on board with the program with one exception, and that would be if an American citizen was targeted, there should be a more robust judicial process. So all of this raises several interesting questions on the U.S. government's policy, and we have two. It's really my dream panel for people to discuss this with you, two of the leading voices, rather than be confused. Muriel on my left. Muriel O'Connell holds the Robert and Mary Chair of Law and is a research professor of international dispute resolution at the University of Notre Dame. She's a specialist in the international law of armed conflict and is the author of numerous books and articles on the subject. I promise I would hold up her newest one. I offered to. The Power and Purpose of International Law. You see it on the Oxford University Press table out there. She's been a professional military educator at the U.S. Department of Defense, and she currently chairs the Use of Force Committee of the International Law Association, and she's a vice president of the American Society of International Law. On my right, Ben Wittes. Ben is a former Washington Post editorial writer. He is the author and editor of several books on national security issues, including Law and the Long War, which I could recommend to anybody who's concerned about these issues. He's now a senior fellow and research director at Brookings, and a member of the Hoover Institution's Task Force on National Security and Law. A little while ago, it was a couple of months, Ben became the co-creator of a blog that's become sort of must reading for the national security community. His co-creators are Professor Jack Goldsmith up at Harvard and Professor Bobby Chesney at Texas. It's called Lawfare. So recommend that. So we're going to do a little different format today. Rather than doing presentations, we're going to try to have a discussion based on a series of questions that will be fairly granular, sort of the who, where, and by whom, as well as broad questions. So I'd like to, and Gabe decided actually with the writing orders, so everyone wants to jump in. Let me just ask the first question this way. Under the applicable legal regime, who may be targeted?
We just go by alphabetical order, is that right? It's rare for an O'Connell to be first in the alphabetical order, so
it's not rare for a Wittes to be last.
Thank you, if I could have my moment. We could do reverse alphabetical order next. Okay, who may be targeted? Targeting with the intent to kill an individual is only lawful under international humanitarian law or LOAC within armed conflict hostilities, and then only members of regular armed forces, members of organized armed groups, or direct participants in those hostilities. An excellent statement of who may lawfully be intentionally targeted, and note, never by police in peacetime, but Philip Alston's May 2010 report to the United Nations Human Rights Council is an excellent summary of the law on this question. Today, the United States is only engaged in armed conflict in Afghanistan. Targeted killing elsewhere is not commensurate with the law. And let me just add to Vince's introduction, he gave the impression that this situation of targeted killing by the United States outside of the armed conflict hostilities in Afghanistan is somehow accepted by the public. I would debate that. Yes, there was a very unfortunate op-ed in the New York Times, poorly informed as to the relevant international law involved. But in addition to many of us in this country who are very concerned about the government's pursuit of individuals to kill them wherever they are, regardless of the situation they're involved in, around the world there is almost unanimous support for the rules that I just stated. I want to quote somebody who I frequently debate on these questions, Kenneth Anderson of American University. I can't disagree with his conclusion that a strategic centerpiece of U.S. counterterrorism policy rests upon legal grounds regarded as deeply illegal by large and influential parts of the international community.
So let me start by thanking Vince for inviting me to participate in this. I feel a little bit outmatched because Mary Ellen's a distinguished international law scholar, and I'm actually a journalist. I sort of dabble in these areas, and I a little bit, I like to think I have something to say on them, but I don't hold myself out as an expert on international law. One of the things about being a journalist is that you do hopefully develop some expertise in common sense. And I want to approach this question from the point of view, start from the point of view of common sense and then go to doctrine. Because I think one flows much more easily from the other than the latter flows from the first. If you take what Mary Ellen just said at face value, that is, to deny that the use of force is ever appropriate, targeted killing is ever appropriate outside of an immediate zone of armed conflict, and you define armed conflict very narrowly, as she does. And you further deny, as she also does, that it is ever appropriate for CIA personnel to engage in lethal force and to participate in these sort of activities. There is a conclusion that follows from that, I think ineluctably. And that conclusion is that the President of the United States is a serial killer. And I don't know that that's an avoidable conclusion. I think the conclusion would have to be that this is not an authorized use of force. It's not an appropriate, it's not confined to the territorial boundaries of an armed conflict. And it's being done by personnel who aren't necessarily authorized ever to use force, even in an armed conflict, all under the specific orders of the President of the United States, who, let's go a step further, campaigned on a promise to escalate the sort of meager serial killing that his predecessor was engaged in, who, furthermore, criticized his opponent in the campaign for being insufficiently committed to serial killing. And proceeds to get into office and do precisely what he promised, which is to escalate the existing sort of low-grade serial killing that's going on around the world. I think under Mary Ellen's theory of the law, the President is really no different from Ted Bundy, or to put it in fictional terms, Hannibal Lecter. And Harold Coe, whom, Vince described as revered by many in the room, would clearly be guilty of conspiracy to aid and abet serial killing, to conspiracy to serial kill. I'm not sure what the term of art for that would be. And so my question, which I mean only sort of rhetorically, and partly I would love to hear Mary Ellen address, is what is the difference between the President and a serial killer, or just garden variety serial killer? And number two, if in fact I'm not misunderstanding her legal argument, why are we having this sort of very staid discussion about whether the President, whether this is, these sort of constituent components of this gestalt awful fact, and why are we not talking about impeaching and removing the President and putting him on trial for myriad, hundreds and hundreds of killings around the world that are unlawful? Now, I would love to hear Mary Ellen address that, but let me step back before I yield this and say, I think the President is not a serial killer. And I think Harold Coe is not guilty of conspiracy to aid and abet serial killing by the President. And if you believe that, then there simply has to be something, at least something, and I would submit several things, defective about the underlying legal theory. One of them is the question of who can be targeted. And the answer to that question is not nobody outside of a very narrow territorial zone of armed conflict.
First, let me say that I take these matters incredibly seriously. I do not dabble in them. We are talking about questions of life and death. We are talking about questions of the good name and honor of our country and of persons who are asked to serve this country. I am married to a highly decorated combat veteran. When he went to war in the Gulf to liberate Kuwait, he did so under clear knowledge that he was honoring the United Nations Charter, honoring the United States Constitution, honoring the Geneva Conventions. He was the Geneva Conventions trainer for his entire battalion. He came home from that war with a clear conscience. He does not suffer from post-traumatic stress disorder. And he understands how important it is that everything we ask our serving men and women to do should be strictly in compliance with the rule of law. And that those who do not know this law, who simply dabble in it, who like to have websites that talk about lawfare as if using the law and supporting the law was the same thing as using lethal force in warfare, should not be engaged in that. We need to have clear rules when we send our people into harm's way. And one of the things that is the legacy of the Bush administration that I think many of us are so very disappointed to see has continued in the Obama administration is a failure to renew our commitment to the law as written, to what we all in the international community accept to be clear rules of law. They must be clear if we're talking about life and death. We should never talk about taking human lives lightly or without a clear justification within the law. Ben's argument relies almost entirely on the logical fallacy of the ad hominem argument. He thinks that we should stop and think, who are these people who are involved? Is this President Obama? Is this Harold Koh? Therefore, we should stop there and not think about what the rules are, the justification, the citations to authority that we should, as lawyers, be looking to before we decide whether or not our president is acting in conformity to international law or not. And I'm sorry to say, very sorry, because I do have great respect for Harold Koh, but in Harold's speech in March at the American Society of International Law, he did not cite any authority except the UN Charter, Article 51, and on that basis, we cannot find, looking at the authority for the interpretation of Article 51, as well as its plain text, justification for the use of killing outside armed conflict territory. The other logical fallacy that Ben makes, in addition to relying on the ad hominem argument instead of actual clear legal justification, is that he has failed to understand, he's tried to make this zero-sum argument, as if you can't find a way to kill individuals under the law of armed conflict, you can do nothing. Maybe we should call this the Chicken Little logical fallacy. It is certainly not true that the only thing we can do is kill people with drones or with secret commandos. We're supposed to be talking about drones today, but it's understood very likely that many of the people on the president's kill list who are outside of Afghanistan will be killed through special operations and covert operations by the CIA or others. Well, we know that there are other means. We know that there are other means, and in fact, other means have shown through studies to be the effective means. So even under the law of armed conflict, even if we were going to say that we had an initial right to kill outside the hostilities of Afghanistan, we would have to justify any of these actions also under the principles of necessity and proportionality. Necessity says that you must be able to accomplish more good than harm. You must be able to accomplish the military objective through use of lethal force and other military measures. But in fact, we've been told by counterterrorism expert after counterterrorism expert that military force, the blunt killing of individuals outside of armed conflict hostilities, is not how you succeed against terrorism. The 2008 RAND Corporation study says that the way in 93% of the cases you have succeeded against terrorist groups, repressing and ending them through incorporating them into the political process, number one, and number two, through law enforcement measures. And that is what the United States had done consistently until 2001, law enforcement. That is what has worked for the British, that is what has worked for others. So put away these two fallacies, that just because it's Harold Koh or Barack Obama, we lawyers put down our law books at the door. And number two, don't think in these narrow terms that have been built up over this amount of time, that all we can do is kill people. It's unsophisticated, it is uncreative, and it is unlawful.
So just to clarify a couple of points. Just to clarify a couple of points. I don't believe that I ever said that all we can do is kill people. What I said was that there are a certain number of cases, and there are a number in the hundreds, in which that is in fact what we've done. And what I've observed is that, understanding Mary Ellen's argument, those would have to be understood as murders. And that if you understand them as murders, and in fact in her papers she describes them as CIA crimes, and specifically describes them as prosecutable, with reference to the CIA officers in question. My point is that these are not simply acts by CIA officers. They're acts by CIA officers at the direct orders of the President of the United States, both in this administration and in the last. And that if you understand them in the way that she does, you are therefore understanding both of the last two administrations as composed of serial murderers. And so I believe that there's something defective about that, because it just doesn't comport with my sense of reality. And so let me propose an alternative way of understanding the question of who may be targeted. A state of armed conflict came into existence in the fall of 2001 at the latest in Afghanistan. Under international law, we think of that as a non-international armed conflict, and you can target people who are directly participating in hostilities on the other side. Under domestic law, we have the AUMF, the authorization to use military force, which the courts have interpreted actually in a somewhat different context. But in the context of habeas litigation in Guantanamo, the administration has asserted, and the courts have by and large accepted, that you can detain people who are part of or substantially supporting enemy forces. Now, I think these two broad propositions, and understanding that the administration takes a rather broader view of direct participation in hostilities than, say, the ICRC does, I think broadly understood, these two instruments give you a pretty good sense of who can be targeted. And you know, you can say, as a blanket matter, that the state of armed conflict is limited to Afghanistan. But I'm really unaware of any history of state practice of being in conflict with an organization A that straddles the border between countries X and Y and asserting no authority to cross that border and target members of that force, members of that group with lethal force. And so I think the questions of who can be targeted and geographically where are intertwined. But the broad answer to the first question is you can target members of the enemy under both international law and under domestic law. And I think that's a way to understand what this administration has done and the last administration has done that does not require you to believe that they are composed of Hannibal Lecters and Ted Bundys.
Then let me drill down a little bit on that. You said the enemy. Who is the enemy? Is it?
We're not going to go through the question.
We are, because I'm going to roll back to I think we're still on food. And I'm going to spend a minute on that, and then
Or have we moved on to where?
You know, they are connected, but let me try to move my way.
We did have a series of questions that we were going to.
And this is, no, we're on the first one. We're on the first one. I mean, I know your answer. Your answer to this question is nobody. So that's why I'm directing it
That's absolutely not the answer to my question.
Well, I can correct the first, Mary.
Go ahead. You didn't have a chance to answer first, so we're now answering.
Hey guys, I went to school, remember the Neil's Error Report? You know, we used to have quiet discussion and without applause and all that stuff. And really, bear with me. Then there's a question of who can be targeted. Enemy leaders, or the ICRC would have to be just people engaged in continuous combat functions, and who are they in your mind? And then how far do you go? Do you go to financiers? Do you go to bomb makers? Where do you draw the line?
I think I wanted to.
You're welcome to.
Was it directed at you first?
All right. Well, I would draw the line as follows. You know, and actually, I think the Guantanamo cases are useful here because they, the courts at the district court level and the D.C. Circuit have struggled with this question rather earnestly over a fairly large number of cases at this point. And what they've, you know, clearly somebody who is part of, as in, you know, membership in or meaningfully operating on behalf of enemy forces is, in the D.C. Circuit's view, detainable. And they judge that on the basis of a very functional analysis of what role they're playing. There is this other question which they have, you know, not had occasion to engage as deeply, which is what level of independent support, if you're not part of the enemy, but you are engaged in independent support of the enemy, what level of independent support would give rise to detainability and therefore also targeting? And I think, you know, there they have not really addressed the question yet. However, what they have said is that there is some measure of support that would qualify you as being covered by the AUMF. And I think, you know, the administration has been careful to argue, try to argue cases as under the part of prong rather than the support prong for both prudential and substantive reasons. The support stuff is much more difficult. But I think, you know, I think that gives you a sort of flavor of the answer in the detention context. And I would think in the targeting context, the answer would be rather similar.
Of course, when you're talking about killing people outside the boundaries of the United States, the law that is relevant is international law. And international law clearly says that in an armed conflict, and again, you can get excellent citations to this in Philip Alston's report, in armed conflict hostilities, the members of the regular armed forces of your opponent may be targeted. Those militias that are organized and supportive of the regular armed forces, if any, and of course those persons taking direct part in hostilities. The International Committee of the Red Cross does have a new category of persons who are in a continuous combat function that Vince referred to briefly. This was a new category created really in the interest or pursuant to arguments provided by the United States and Israel that there should be another category of persons who are regularly fighting, even if at times they step out of the fighting. So there is now a new category that we're looking at. But the International Committee of the Red Cross did something that I think was extremely important for all of us to take note of in creating this new category, and it really does characterize what the U.S. can and cannot do lawfully outside this country in terms of the use of lethal force. And that's if somebody's in a continuous combat function, perhaps a member of Al-Qaeda, who we know to be in that function. Of course, Al-Qaeda is a large and complex organization or series of organizations, so it's important to have good, precise, factual information about individuals. But at any rate, if that person is in a continuous combat function, you may only target and kill the person in situations of necessity. In actual battlefield hostilities, the situations of necessity are clear. In Kandahar right now, our Marines, the members of the United States Armed Forces are in a situation of hostilities, and they can rely on a reasonable assessment of necessity to carry out acts of lethal force. Outside of such armed conflict hostilities, as defined by our International Law Association committee of 18 members from 15 countries, you cannot kill somebody under that level of necessity. Then you have to go to the police or regular law enforcement level of necessity because you simply do not have evidence of what category that person's actually in. You may have some CIA person who has paid a bribe to get some information about an individual, but that's hardly the basis on which you should be killing them. So if they're about to actually carry out, immediately about to kill another person, take human life, then under police rules, yes, to save human life, you have a situation of necessity and you may kill that person. But without that kind of evidence, who are we killing? Vince gave you some statistics earlier, but the widely respected New America Foundation website, Peter Bergen's statistics are that in Pakistan alone, since we started using drones, these are just drone attacks, since 2004, we've killed approximately between 1,210 and 1,863 individuals in Pakistan alone. So the government's statistics about who's being killed, why they're being killed, I'm sorry, we have to be very skeptical. We have to hold our government to a higher level of legality and for making their case than we've heard so far.
And can I just follow that? And so I want to clarify, when you say that these killings take place outside of the zone of armed conflict, maybe by DOD, maybe by CIA, maybe by some combination of the two. They're not, lawful under the law of armed conflict. How should we understand what they are, in your view?
Ben obviously wants me to address whether or not, according to using his terms, the president's a serial killer or not, because this obviously will, the president is popular, Harold Koh is popular, and this will somehow undermine the argument that we should really be following the law here. So let's talk about that. I'm as disappointed as anyone that we do not have a reversal of certain Bush administration policies that developed after 9/11. I heard many of my colleagues who were very willing to say that President Bush had authorized torture and that this should be ended and that President Bush and other high members of his administration should be prosecuted for that. I'm afraid that it's only acceptable that we hold President Obama to the same high standard of compliance with international law. And I think it is actually unfortunate that in the international legal community we've been slow to do that. I think it's understandable. We were told during the campaign that the global war on terror was over. We expected, because Harold Koh had been such an outspoken opponent of lawless policies by the Bush administration, that he would take the lead. We're not seeing that yet. I think we will see it. I think as the information gets out, as we get good arguments, as our colleagues around the world, and I just came from London where I gave several talks on this issue, and there's still disbelief in many parts of the world. President Obama is very popular, but the statistics, the information about the drone attacks in 4 countries right now, 3 in which the United States is not participating in armed conflict hostilities, as well as the details that are coming through out of the al-Awlaki case. And there's real disbelief that our president would be willing to send a hit team or have even American citizens on a hit list for killing, instead of doing what the British have long maintained to be the way to repress terrorism, which they did successfully with regard to the IRA, which did have worldwide connections, which was a violent organization with ties to the PLO that had state support, a very serious organization, and through a combination of law enforcement, sometimes practiced by the military, but under law enforcement rules as enforced by the European Court of Human Rights, and as a result of engaging a political process, today there is peace in Northern Ireland. We, 9 years after the 9/11 attacks, don't see the same kind of success. So yes, I'm very disturbed. I'm very sorry. I am willing to say that so far the United States has engaged in, our leaders and their lawyers have been willing to engage in unlawful killing.
Let me give you ask you to follow up on a point that Ben raised. And he suggested that state practice actually tends to support the view that war goes where the enemy goes, and so that would be a basis to be outside of Afghanistan. And kind of a related question. It's one thing to say that the British were able to deal with the IRA, but are the Yemeni police really up for suppressing Al-Qaeda?
Thank you. I think those are both very good questions. I appreciate getting them to answer. State practice. What is a state practice in this area? First, we have to be very clear. When you're looking at examples that are being given and so forth, you need to always look at the critical law involved here, and that is the law after the Second World War. We are looking at the UN Charter. We are looking at the Geneva Conventions of 1949. We are looking at the additional protocols of 1977. And most critically, we're looking at a whole body of human rights law that has grown up. So many people in this debate like to say, so many people on the other side who are supporting targeted killing like to say that international law is somehow stultified, that it never changes. In fact, it changes as needed through consensus decision-making by the international community. And the law that we have today is up to date and is up to the task. And that law, which progressively closes the area in which you can use armed conflict force, the level of force at the armed conflict level, and raises the human rights of individuals everywhere, is the law that governs us today. So the state practice, we can see, was relied upon by the International Court of Justice in its 7 cases dealing with the use of force. The most recent one, and the one I usually cite as most on point, is the Congo versus Uganda case of 2005, but we can also look at the genocide case of 2007, and we can see that the court says if you're not dealing with groups that control territory, are either a government or a quasi-government, then you need to use force commensurate with the kind of organization you're opposing. And that means law enforcement or lesser force based on the principle of necessity. So in Congo, Uganda, where there were cross-border attacks going on, but those attacks were not the responsibility of Congo, Uganda had no right to use military force on the territory of Congo. Uganda could take cooperative measures with the government of Congo to help enforce its territory, and I'll get to that. That's what we were doing in Yemen quite effectively until 2000. Or it was also lawful for Uganda to take measures on its own territory to prevent that infiltration. So the U.S. was doing exactly what the court called for in Congo, Uganda in 2000, when we were pursuing those persons who had attacked the USS Cole, the loss of life of 17 sailors. I hope many of you saw the op-ed by Ali Soufan in the New York Times of just about a week ago, and that he was an FBI agent sent to Yemen to work with Yemeni officials to round up those who were responsible for the coal. They did so successfully. And then Soufan tragically points out that the U.S. took its eye off Yemen, known to be a country that has experienced civil war, instability, that needed support, that needed the constant building of its criminal justice system, of its infrastructure, of its economy, of its respect for human rights. And instead of staying and doing that, we got involved in foreign adventures, the war in Iraq, and as a result, Yemen was the individuals who were arrested through the good cooperative efforts of the FBI and Yemeni authorities got away, escaped from prison, bribed their way out, whatever. So the clear theory is that if we had gone back, if we had done the right thing 10 years ago, we'd be in much better shape today. So it's too late to rewrite, but it's not too late to get it right going forward.
We do have about 3 more questions to get to, and I want to leave ample time for Q&A, but if there's something you'd like to do.
Well, I'd like to just be, Marianne put a huge amount on the table here, and I'd like to address 2 points, and I'll leave the rest for later. So it is, very easy to say that there is, the fact that a state is weak doesn't convey any authority to use force on its territory. And I'm sure there are a lot of, high-minded sounding opinions of the ICJ that one can cite for that proposition. There's a perfectly beautiful movie made in 1938 called Grand Illusion, which ends with 2 French POWs who've escaped running across a field, and German soldiers, this is in World War I, pointing their rifles at them, and they're about to shoot them dead, and one of them says, "Wait, they're in Switzerland." And that's the end of the movie. And it's one of the great movies on any subject ever written, ever made, certainly on the laws of war. And the point of that ultimate scene is how quaint the old ways are. And this was made in 38, just before those old ways' quaintness was very much revealed. The idea that a country that is using force is going to stop because somebody makes it into the territory of some other country is, as a general matter, a difficult proposition. And when you're dealing with countries that have no capacity or willingness to exercise the law enforcement functions that Mary Ellen is insisting is the only legitimate way, is frankly fantastical. If there is a large and coordinated group of people who are attacking us from an ungoverned space in the world, and the country that has notional sovereignty over that space is unable or unwilling to do something about it, where that country is able and willing, like France, England, Egypt, it doesn't even have to be democratic countries, right? There is a very, very strong principle of respect for their territorial sovereignty. That principle has to give in certain situations. And one of them is the situation in which you are simply resigning yourself to having no capacity to address the problem if you consider that line between where the soldiers are, they've made it to Yemen, gotta put down the guns. It's not a position that comports with the reality in which states live. And I'm unaware, by the way, of any state facing a serious national security problem and a serious security threat that has honored that principle.
Let me ask you a couple of questions together in a short period of time. How does the ban on assassinations, the U.S. domestic law ban on assassinations, play into this? And then, relatedly perhaps, maybe not. What about CIA involvement? I mean, why are they unprivileged enemy belligerents just the same way Al-Qaeda is?
Well,
who wants to go first?
I guess I'll address this one first. So the assassinations ban is a peculiar instrument, and it forbids categorically assassinations which it does not define. And I believe it was always understood that whatever assassinations mean, it only means something that is unlawful under domestic law, since it's not a term of international law. And so, here's, I think, the broad parameters of what it means. It clearly doesn't mean somebody who's a combatant, because that is authorized, by domestic law. It clearly doesn't mean, I think it does mean, the killing of a political leader of some country. I think it has, under domestic law, very unclear meaning, and in any event, is, after all, just an executive order that is, presumably interpretable by the executive branch as such. So I think there's no particularly satisfying definition of what it encompasses. I think it's very clear that the executive branch institutionally, both under the last administration and under this, does not consider it an impediment to operations of this nature.
Just very briefly, I'm not an expert on U.S. domestic law on this question, and I don't speak on points of law about which I am not an expert. But I will refer you to Harper's Magazine, Scott Horton, who is an expert on these topics. He has an excellent piece on May 3rd in which he finds that the U.S. designation, the U.S. targeted killing program, as carried out by the CIA, is clearly in violation of the 1947 statute that set up the CIA. So I refer you to that and many other excellent pieces on the domestic law involved. And I might just pick up one other U.S. domestic position, because Ben thinks it's fantastical that we would reserve or restrict targeted killing to the battlefield and not allow it against those who would create serious challenges to the United States through their acts of terrorism. But that's exactly what Ambassador Indyk said during he was a Bush administration appointment as ambassador to Israel. And in July 2001, he made it very clear to Israel that the United States legal position is that targeted killing is unlawful.
Now that we're running late, I'll ask each of you whether you want to say anything else before we turn it over to the audience. Okay, go.
Just one word on self-defense.
Sure.
The other thing that we didn't really talk about was, well, maybe we did. Let's see what your questions are. If there are questions, actually, we did. Right.
I have two questions. One for Alan and one for Mr. Wittes. For Mary Ellen, I would ask this. I know you're very familiar with the work of Professor Yorobinski, this great scholar, who I have often battled with, but nonetheless, he has a theory of what he calls extraterritorial law enforcement, which is in connection with a war going on in State A, but where there are individuals in the adjacent state, State B, who are, let's say, lobbing missiles at the armed forces of a particular country in State A. And he maintains that, at least across the border, if you do have people who are attacking your armed forces, he maintains under the theory of extraterritorial law enforcement that there is a right to go after them for specific self-defense purposes. Now, obviously, Afghanistan and Pakistan is a clear example of that. I'd be interested in your take on his theory. And for Mr. Wittes, I would just ask you this. If a spy agency from another country, or if an armed force from another country decided it was going to send drones over the United States and target and kill people within the United States that it considered to be a threat to their security, presumably under your theory that would be perfectly acceptable. Is that your view?
No, not at all. And believe it or not, there's no conflict between that view and... So look, the United States has the capacity to cooperate and to neutralize lethal threats to other countries. It has robust law enforcement capacity, and it has shown no dearth of willingness to arrest, prosecute, and detain people accused of material support of foreign terrorist groups directing attacks at other countries when asked to cooperate by other countries. And my view is that the territorial sovereignty, the restriction on military operations on the sovereign territory of a country gives way when that capacity is unavailable. And so, you know, I think if a foreign government comes to the United States government and says, you know, Ben Wittes poses a lethal threat, he's a member of a combatant force against our, and here's the evidence of that, and you know, they have recourse through that, and the U.S. government is quite aggressive in those situations. Now, and for exactly that reason, there are, you know, more than 150 countries in the world in which we do not engage in lethal force, in lethal force of the type that I'm defending in a few discrete contexts. And the discrete contexts in which I'm defending them are A, in a battlefield setting, as Mary Ellen concedes is appropriate, and B, in situations in which people have taken, combatants, people fighting us, attacking us, have taken safe haven in an ungoverned space where they are not reachable by conventional means. And I think if you imagine, for your hypothetical to actually present itself in a challenge to what I'm arguing, you'd have to imagine some area of the United States in which federal power does not meaningfully reach. And that's,
Texas border.
Wow, and that leaves 42 countries in which Ben believes the United States is or is.
No, I said more than 100.
Alarming because, as far as I was able to gather, we're using lethal force unlawfully in 3 countries right now. So this is. But notice the argument that Ben uses. It's often out there in these discussions, unable or unwilling. Valerie, that is not the legal test. Whether the country is unable or unwilling. And he also says that these are ungoverned territories. There's only one country in the world that the United States officially believes, or is our official position, is ungoverned, and that is Somalia. And even in Somalia, because we are not involved in armed conflict hostilities in Somalia, and heaven knows we do not want to be, if we were to undertake any action on the territory of Somalia, it would have to be of a police enforcement action, such as we have the right to do with regard to pirates, under a Security Council resolution. We could, perhaps, and I would prefer to see a Security Council resolution, but under a theory of countermeasures, violate Somalia's right of non-intervention by using law enforcement measures to go after, to try to attempt to arrest and charge with criminal wrongdoing those persons for whom we have sufficient evidence that they're involved in terrorist activity. But that's a lot of this, and an exceptional case. The claim doesn't apply elsewhere. Elsewhere, we have to try to model the good citizenship that we have long felt is our greatest contribution to the international community. And that's what Valerie's talking about. We don't want other countries to say, well, if the U.S. does it, we can do it. We all know how China describes its enemies, how Iran describes its enemies. They have drones. Do we really want those to be the rules of the game? No. We need to start modeling and complying with the rules we want to see everybody go along with. And if we just look at the data, we'll find, just as with the torture case, not only are we talking about the lawful way to act, we're also talking about the moral and effective way to act. This is not asking a lot. It's just putting the case to the American people. It's not as dramatic as with drones, but it's going to work in the long run. And that's what I would actually say to Norm Dinstein. He doesn't have a case for sending commandos onto the territory of a country that he says is not able or willing to control their land. We have this in a number of International Court of Justice decisions, and I, as an international lawyer, look to the International Court of Justice as the chief legal organ of the United Nations with special expertise in interpreting the United Nations Charter, with 9 judges of great respect and great knowledge of international law per se. I don't dismiss that court, as I think we've heard Ben do. The International Court of Justice has made it clear in Congo, Uganda, in Nicaragua, in Corfu Channel, that you police according to, on your border to defend and to take care of these kinds of issues. You cooperate with the territorial state, that which does, by the way, have a long-term beneficial impact on that state, and you reserve the use of lethal force for targeted killing or armed conflict hostilities for actual armed conflict hostilities.
I would just note, just very briefly, that at least, unless I'm wrong, the United States does not accept the compulsory jurisdiction of the ICJ. And so it's interesting that Mary Ellen keeps coming back to an authority that is not, in fact, recognized as binding by the government of this country.
Ben, I'm sorry, I have to correct that. The United States is a party to the statute of the International Court of Justice. We have recognized its compulsory jurisdiction in many, many treaties. It still has compulsory jurisdiction in many treaties to which we are a party. We do recognize the authority of the court. We've just sent a person of great respect in the State Department, Joan Donahue, to be a judge of the International Court of Justice. So it is simply not the position of the United States not to respect the authority and the competence of the International Court of Justice. We've lost some cases, which we didn't, which we did not make strong arguments in, which we were not in a good position to win. And you do hear a lot of criticism of the court, but in every litigation I've been involved in, the party that lost likes to complain about the court.
That's really a different panel, which that serves.
Two quick questions. One, you mentioned that to the extent that you have cooperation with the territorial government, then you support it is lawful. And this isn't an official account, but according to Wittes' recent book, there is quite a high level of cooperation with the Pakistani government. And in his account, at the very least, the drone attacks have been authorized at high levels of the Pakistani government, which has distinguished between that and intervention by special forces, which they haven't agreed to. And there's an ongoing negotiation over that. So do you think, assuming that that's true, do you think then that solves the case, and that would solve the case also for the Yemenis government? And the question is, what level of, how public does the cooperation have to be? Because it could be problematic for the host government to sort of publicly embrace it while they actually agree with this. And then just to extend your analogy to liability for the legal advisor or the president, do you think congressmen would have liability for financing some of these programs? Because there are appropriations bills that are used for these programs. So to the extent that you hold the legal advisor and the administration liable, would you also have to hold the legislature liable?
Well, so that's a very interesting question, actually. Just to be clear, I posed the question rhetorically by way of highlighting what I think is the radicalism of Mary Ellen's position, which she will not state. And it's interesting to me that she comes back to, she finally, after a very long response to my question, was willing to settle on the words unlawful killing, but will not speak the words murder or serial killing, which is really what she's describing. Yes, if I thought that's what was going on, I would have to say the conspiracy in the US government is extremely broad. It's after all, these programs are specifically appropriated. The congressional, both congressional intelligence committees have been extensively briefed on. Interestingly, you haven't heard a peep of protest from members of the intelligence committees about these programs. And so I think if you really take seriously the idea that these are, extrajudicial killings / murders, and the numbers that she cites are astonishing. I mean, we think of a serial killer as pretty prolific when you're talking about 10, 20. I mean, you're talking about 1,000 people, right? And you're talking about buy-in, extraordinary buy-in from Congress. And so I would think that you would have, if Mary Ellen's theory is correct, you have a very broad-based problem of people knowingly contributing to activity that she describes as unlawful killing, and in her writing makes clear are prosecutable.
And then in your next op-ed, you have to give attribution to the financing.
Yes, it's interesting that I'm being called the radical, although I keep putting forward statements of what the law requires, trying to get us into compliance with the law, which I always thought was the conservatives' position. So,
I certainly never held myself out as a conservative, so.
Well. My whole career and my purpose in life is to promote the rule of law in the world, and I consider that to be a quite conservative position, so I'll take the label conservative. Why do I not say murder? This is a term that is used for criminal prosecution. persons who have had a chance to have a trial to make their defense and so forth. I don't throw that term around lightly. I do want to see the United States get into compliance after the tragic years in which we were using torture in this country and there were no prosecutions. I don't hold out hope that there will be prosecutions for extrajudicial killing. My more immediate concern and purpose, where I hope all of us who will leave this room more committed to act, is to stop future killing. We know that many countries have had their leadership commit very serious violations of international law with no accountability. The human rights community, international law community is committed to trying to change that, but we've had a setback over these last years, and I don't expect it to happen, so I don't see any real purpose in arguing about those matters. I'm interested in going forward and getting our country into compliance with international law, and we can talk about accountability later. I'd like to now answer the very good question put with regard to Pakistan. Pakistan is a very complicated situation. We carried out, it looks like it's going to be something in the order of 200 strikes there by the end of this year. Those strikes are occurring in a variety of situations, some of which are defensible, some not. Some of the strikes have plainly been part of Pakistan's own armed conflict hostilities in Pakistan against insurgents who are opposing who are organized armed groups posing a real armed conflict threat or forces of, certainly in Buner province when there was an actual attempt to take over sovereignty of that province. It was certainly, in my view, lawful for the Pakistani armed forces to push back. And if we coordinated a drone strike with Pakistan in those operations, the act itself, this is another question about who in the U.S. was carrying out the act, but the act itself is justifiable under the law of armed conflict. So there are, in my view, there are surely some drone attacks in Pakistan which are justifiable. But other places where the U.S. has carried out drone attacks, but Pakistan itself has not been engaged in armed conflict, even with Pakistan's consent, I have serious questions under human rights law whether we could do that, whether they had the consent to do that, and that would be my point with regard to Yemen, where we are involved in no Yemeni armed conflict. So even if Yemen says to us, you can carry out your drone strike, or more recently in May we carried out a cruise missile attack from a fighter jet, that even if we had consent to do that, because it's not part of armed conflict hostilities that are going on in Yemen's territory, there's no lawful basis for doing that. And then, of course, there's the third category, which is occurring mostly in Pakistan, where Pakistan plainly has not given us any kind of consent. And this is with regard to the al-Haqqani network. Al-Haqqani is generally supportive of Zardari, and he has not wanted us to go after al-Haqqani, and those are the most questionable of all. But so we have to be good lawyers in these cases, very precise, and make it clear where not the U.S. is acting lawfully.
I'd just like to address that very, very briefly. I think it is a very dubious undertaking to sit here without access to classified information and purport to know what level of consent we have from what governments to do what on their territory. I don't purport to know that, and I don't know where Mary Ellen purports to know that from, but I would just treat with a lot of skepticism the idea that there is major, ongoing, over a number of years, military action taking place on Pakistani soil by U.S. forces without some significant degree of cooperation and consent. And indeed, there has been a lot of press reporting to the effect that a lot of the targeting information is being fed us by Pakistani forces.
Just one point in defense of my reputation. I'm a specialist in the law of armed conflict and in the definition of what armed conflict is. We can look at the facts in countries such as Pakistan and Yemen, very open public sources, and understand what situations are and whether they are places where the U.S. can use armed conflict level military force or not.
Let's take two more. First one, top row, sir.
Thank you very much. I'm a foreign lawyer and not a U.S. lawyer, and I want to give a foreign lawyer's perspective specifically on the question if a CIA officer kills on the authority of the president, is that an unlawful killing? And I think it's very important to distinguish between what the foreign affairs powers of the president are under the US Constitution and what international law says. And I'm very sorry to say this, and I don't think it's going to go down well in this room, but the US Constitution is for people who are non-US citizens one of the constitutions in the world. And it's a very, very well-written constitution. It's an extremely influential constitution, but that these qualities do not give the US more authority, legal authority on the international legal field to do as it pleases, even if there are very good policy arguments in favor for that position. So I think the question whether, I mean, the issue is not whether the US Constitution gives the president these powers. The question is whether international law allows that. And I think Mary O'Connell gave a very conclusive argument for that. On international law, it's a violation to kill on such a basis. And whether the US president or the CIA operative who commits these killings is liable, that's a question of international criminal law. But
you quickly wrap it into a question.
The last conclusion is the US is violating international law no matter what the Constitution says.
Anyone want to derive a question from that?
Well, I would just say that no part of my argument has depended on the constitutional authority of the president, so I'm not really sure that. My only point about the president's authority is that when you describe what the CIA is doing as crimes, as Mary Ellen has, it is important to note that the CIA officers who committed those crimes, if you call them that, are acting at the direct behest of the President of the United States. And therefore, those crimes cannot simply be described as the actions of individual CIA officers. It has to be imputed to the President. That's not an argument that is therefore lawful. It's simply an argument that Mary Ellen's point is much more dramatic than simply that a few CIA officers are guilty of unlawful behavior.
For persistence.
Thank you so much. This is my 7th year attending this conference. I've never seen a panel like this. This sort of dropping the other person's name and making personal attacks is really unfortunate because I, like many of you, came here looking for a rigorous, analytic, intellectual discussion. And I don't know who's responsible for the selecting panelists or the way this went. Mary Ellen, I've seen you speak before. I've read your books. I think you're wonderful. But to engage in this kind of back and forth is really unfortunate.
You know, I think, let me refine that. There's somewhere between, this again, remember, you probably know what I'm talking about. With Neil there report, it was a solid, quiet discussion among serious people on all sides of the spectrum, maybe on PBS at 7 p.m. There's somewhere between that and MSNBC and Fox News. And that was the tone we were trying to strike. I think we pretty much hit that. I'm pretty happy with it.
This is not a question because this was a comment, not a question.
Series.
Can I have a question?
The best panel of all 3 days.
Thank you.
Appreciate
Can I
that.
have a question?
And the liveliest.
All right, one comment, then we have to go.
My question is actually, Vincent, you mentioned that targeted killing is, it depends who we kill, right? We're on the question of who the person we can kill, and under certain circumstances, if it's necessary, and other criteria, there is target killing. The partner also agrees. So now I have this question, why shouldn't we develop the same logic and rule of law with regard to targeted torture? Because if you can go and kill somebody in another country because so target torture, if you take that same person before you kill him and you torture him in order to save other maybe people, and if it's necessary, why is that not allowed?
Reed Benn's law and the law and war and Phyllis Bobbitt's determined consent and Mary Ellen's what?
Well, at least I do actually think that the case against torture is even clearer than the case against targeted killing. Torture is absolutely prohibited, whereas it is there. You can, as it was just said, on a battlefield, there would be some justification in targeted killing. So it is not in the same clear, absolute category. But it is true that I'm hearing many of the same kind of arguments for justifying targeted killing that I thought we had answered and pushed back on with regard to torture. And I find that very disappointing that many of the same arguments, necessity that we have to stop this group that's an existential threat to us, and therefore we can go outside the law, or we can weaken the usual justifications for international law. I'm hearing those same arguments again, and I'm hoping people will respond as vigorously as they did before to the arguments against the use of torture.
Thank you very much. We are way over time. I want to thank the panelists very much.